Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin wassalatu wassalamu ala sayyidina Muhammadin asyrafil mursalin wa ala alihi washabbihi ajmain. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Firdaus bin Abdul Samad. I'm an eMIF student. Today I will talk about Shariah Audit exercise of an Islamic financial institution. Before we begin, let me start with what is Shariah Audit. Shariah Audit is a way of assessing or ascertaining whether the practice of the financial institution conform to the relevant Shariah standard and guideline. In technical terms, Shariah Audit refers to the periodical assessment conducted from time to time to provide an independent assessment and objective assurance designed to add value and improve the degree of compliance in relation to institution business operation, with the main objective of ensuring a sound and effective internal control system within the Shariah compliance. The standard and guideline as referred here is a standard as issued by the Shariah Advisory Council of Bank Negara Malaysia, Shariah Governance Policy Documents, and the Shariah Guideline of the particular institution. And last but not least, the relevant policy and procedure for each product and transaction. The integral part of Shariah Advisory Council of Bank Negara Malaysia in Islamic Finance practices in Malaysia can be illustrated in the case of Tan Sri Khalid Ibrahim against Bank Islam Malaysia Berhad, when the Court of Appeal in the view that Section 56 and 57 of the Central Bank of Malaysia Act 2009 contain crystal clear provision and reaffirmed the judgment made by the High Court Judge, Justice Muhammad Zawawi Saleh, that mentions Section 56 and 57 of Central Bank of Malaysia Act 2009 is valid federal law enacted in Parliament concerning Shariah matter, and Shariah Advisory Council was a statute appointed expert with the task to ascertain Islamic law for Islamic financial businesses. In lieu of that, the fact that the court is bound by the ruling of the Shariah Advisory Council under Section 57 of Central Bank Act does not assert the function of the court in providing resolution to the dispute. And then it was further reaffirmed by the Court of Appeal that the Shariah Advisory Council, like any other expert, need to provide ruling pertaining to the Shariah matter in Islamic financial institution when it is required to do so. Now we come to the very important element of the Shariah Audit. How is Shariah Audit being done? First, the Shariah Audit is done by way of Shariah Auditor reviewing the actual transaction documentation of that particular product to make sure that the process and the sequence of the transaction conform to what has been approved by the relevant Shariah board and also the standard as applicable. In practice, before we start Shariah Audit, we need to predetermine our scope of Shariah Audit, which usually shall cover all aspects of Islamic financial institution business operation and activities. This including but not limited to audit of financial statement of the Islamic financial institution, compliance audit on organizational structure, people, process and information technology application system, and review of adequacy of Shariah governance process. The bank also may appoint or employ an external party or person to conduct a Shariah audit on the operation of the institution. If the bank, it is desirable or in the interest of the Islamic financial institution to do so, in which the case, the remuneration expenses relating to the appointment shall be borne by the Islamic financial institution per se. We can divide the Shariah audit into three main phases. The first phases, we call it as a Shariah audit planning. Second phases, we call it as a performance test of control and test of transaction, and the third phase is complete the Shariah audit and issue an audit report. In regard for the first phase, the Shariah audit planning, we really need to understand the business and industry of that particular Islamic financial institution are venturing into. Different industry will normally require different approach. Other than that, we need to perform preliminary analytical procedure. So what is analytical procedure? Analytical procedure can be defined as a type of evidence used during an audit. This procedure can be indicate possible problem with the financial record of a client, which can be then investigated more thoroughly. Analytical procedure involve comparison of different sets of financial and operational information to see if the historical relationship are continuing forward into the period under review. In most cases, this relationship should remain consistent over time. If not, it can be implied as the bank financial records are incorrect, possibly due to the error of fraudulent reporting activity. Take it for instance, in this case, as illustrated in the Maybank Islamic Berhad financial statement, we can see a significant ratio between the financing and advances as compared to the total asset, which around 76%, and it implied that the audit team need to emphasize and focus all the resources and most of the resources to the Note A12. For the second phase, in this particular phase, the auditor will perform both test of control and test of transaction in order to assess the level of control risk. In this particular stage, usually the auditor will assess Shariah non-compliant risk and other potential risks such as likelihood of misstatement in the financial statement. The auditor need to understand internal control and assess control risk in order to develop overall Shariah audit plan and Shariah audit program. In order to examine the internal control, the auditor need to understand the process flow, authority limit, and more importantly, who signed the documents. The team of auditor usually accumulate all finance evidence and engage with the process owner or relevant stakeholder in order to evaluate the audit finding. In order for the auditor to evaluate the evidence, it is important for the auditor to articulate and read the contract between the bank and the customer. In practice, the auditor will read and vet through the master agreement between the bank and the customer in order to find any inaccuracy and mistake. Then the auditor need to do the vouching or cross-reference with the Shariah standard or the policy document as imposed by the authorities such as Bank Negara to ensure that the document was inconsistent with the standard. It can be seen, taking for example in this particular slide, we can see the Maybank Islamic Bank Berhad do a buy, murabaha and musyarakah and al-ijarah nama al-buy and ijarah document contract. In this particular aspect, under Note A12 means that the auditor need to articulate and also read and vet through the master agreement pertaining to these 5 items. In the third phase and the last stage of the Shariah audit exercise, the auditor need to complete all the Shariah audit finding and issue a final audit report. After the thorough articulation of the document, usually the auditor will then issue a Shariah audit report and communicate the finding with the respective internal authorities such as the Board of Directors or the Shariah Board. In another perspective, why we need the Shariah audit? Shariah audit is basically the crucial element in Islamic financial institution because it will ensure the Islamic financial institution become more resilient to prevent misconduct or malpractice from Islamic financial institution per se. Taking for example, during 2008 financial crisis, Islamic financial institution proved to be more resilient as compared to conventional financial institution. However, there are some examples of insolvency in Islamic finance taking place after the global financial crisis and well before that, which can be looked to in order for us to learn some valuable lesson about insolvency and bankruptcy in the Islamic finance context. For instance, in South Africa, there is one bank called Islamic Bank Limited, which was granted bank status in 1988. One of the main reasons for the failure of Islamic Bank Limited is the Shariah non-compliance activity that frequently happen in that particular bank. The summary of the Shariah non-compliance activities in Islamic Bank Limited can be divided into numbers of categories. More importantly, the first Shariah non-compliant activity is in the mudarabah deposit. The Rab al-Mal is liable for the losses, but the losses was not allocated to the depositor, and the losses is mainly due to the negligence and it was not absorbed by the bank. Second, there is not a contract in place for short-term mudarabah contract. This is quite crucial because in Islamic finance transaction, the documents contract is very important and crucial element to ascertain the terms and conditions as agreed by the parties in the contract. What is the lesson learned from the Islamic Bank Limited cases? Many lessons that embedded in the downfall of the Islamic Bank Limited that provide us a good insight for the Islamic financial institution in general and Islamic Bank in particular. On the other hand, Islamic Bank Limited was involved in gross misconduct on both Shariah and operational level, showing both the lack of and need for proper supervision of the Shariah complaint entities. More precisely, if Shariah audit has been in place, it would possibly have curbed the non-compliant activities. In doing so, we cannot take for granted the need and requirement to do a periodical Shariah audit in any Islamic financial institution. This is to ensure that the rights and interests of the customer and depositor are taken care of. Other than that, Islamic financial institutions also need to provide mechanisms to protect the depositor fund by providing deposit insurance and upholding the principle of Sharia. The central bank also need to ensure that their role as the lender of last resort (LOLR) to be upheld accordingly. To sum up, in a nutshell, Shariah audit is a way of ascertaining and confirming that the practice of the financial institution is in compliance with the relevant Sharia standard and the direction given by the Sharia board. This is basically to ensure that a good governance is achieved in that institution. The Islamic Bank in South Africa, for example, collapsed because of the poor management, improper accounting system, and large unsecured lending, which caused damage to balance sheet. In Sharia perspective, there is no such thing as a quarter or half non-compliance. The damage caused by mismanagement and Sharia non-compliance will not only result in customer to be suffered loss, but most importantly, it is prohibited by Allah Subhanahu wa Ta'ala. Thank you very much.